Welcome back to the channel. Today, we're diving into the jaw-dropping case of Anthony Mendoza, a man who's been skating on thin ice with probation after a third-time DWI on paper. He had 6 years hanging over his head, suspended only if he followed the court's rules. Spoiler, he didn't. What unfolds is a legal rollercoaster filled with missed programs, bold denials, an aggravated assault, arrest, and even a one-word email reply to probation that will leave you stunned. Stick around, this case is the definition of second, third, and fourth chances gone wrong.
Good morning, are you Anthony Mendoza?
Yes, ma'am.
And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated, third or more. That was a 6-year sentence that was probated for 6 years.
Okay, quick legal breakdown. He was already on probation for a DWI with a 6-year suspended sentence. That means mess up, and he goes to prison. Spoiler alert, he messed up ... a lot.
Years. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir, yeah.
Are there any additions or corrections to that report? Mr. Parker, you may proceed.
Well, a couple things I want to address. It's a situation I see quite a bit where he's ordered to have to scram and interlock. It's costing $600 a month, and he's having to go to work, but yet he's not supposed to drive, and so he's driving with an invalid license, and then he's not able to work, and he can't.
Here's where the drama really begins. Mendoza's attorney argues that probation was too expensive, $600 a month for the monitoring devices, plus extra costs for mandatory programs. On one hand, that's a real financial burden, and many defendants face this exact struggle. But, on the other hand, probation is designed to be toughets, an alternative to prison, not a free pass. The real kicker? While complaining about money, Mendoza was allegedly still drinking and ignoring court orders. So here's my question for you. Should courts reduce costs for struggling defendants? Or is that just an excuse when someone keeps breaking the rules?
Afford to pay for the things, he needs to do, such as the 12-step program, the GD program, all those things require money. And that's one of the big issues. But the things I'm concerned about is that it says that he went to the safety relapse program. I'm not sure exactly what happened, but he says he never went to the safety relapse program. I don't know if he was ordered to go and he didn't go, but I think he was in custody at the time, and I'm not sure how that happened. But he also says he's never tested positive for cocaine, which is alleged in here. It addresses an issue that he apparently had with one of the directors of the facility where he became combative. This also, in turn, is tied to a scram device. He ended up developing a big sore on his ankle, so he would put his sock behind the scram device. And in this incident, he was frustrated and he wanted to take his boot off to show the director the problem he had. That's when they were saying that he was being disruptive. He has no other felonies, Judge, and he wants opportunity to go back to he wants to complete his probation. He wants to do the safety relapse. I'd like to hear what they say, what happens with that, but I'm sure there's an explanation. I think you'd also like to address it.
Well, let me first make sure I've got the timeline, because it appears that I see that safety he completed and then was placed on zero tolerance in the high-medium caseload. And after that, there was an issue where he was testing positive, again, for alcohol and cocaine, which I understand he denies the cocaine, but that's what this alleges.
Let's pause here. The judge lays it out clearly. Mendoza had already completed a treatment program, but quickly slid back into violations, testing positive for alcohol and allegedly cocaine, which he flat out denies. The contradiction is glaring. Courts don't just slap on drug allegations without lab results or records. So if the report says cocaine, it's there for a reason. And yet, Mendoza insists he's clean. This raises the big debate. Is this denial a defense mechanism, or does the system sometimes get it wrong? Drop a comment below. Do you believe his denial, or is this just another excuse?
And in October of 2022,
So let's recap. He's skipping mandatory programs, ignoring court orders, and still denies drug use. But wait, he's not in custody. How does that even work?
Assuming through an administrative hearing, was granted relapse safe P.
There was a motion to revoke that was filed in the court because relapse safe and
So he wasn't in custody. Okay. And then, so we didn't see him again until August 11th of 2023 when he was arrested in Houston. So here's the thing, whether you probably didn't get any paperwork. Come up here to the front, in the middle here. From at least October of 2022 until August 11th of 2023, you wouldn't have known about anything because you quit going to probation. You were an absconder. And the only reason we found you...
And here comes the plot twist. After ghosting probation for nearly a year, Mendoza isn't caught until Houston police arrest him for aggravated assault with a deadly weapon. That's not just skipping a meeting, that's stepping into serious felony territory. Imagine the judge's perspective here. You've given this man chance after chance, and instead of reforming, he's now facing a violent charge. This isn't about missed AA classes anymore. It's about public safety. What do you think? Should a violent arrest automatically end probation? Or should judges still weigh rehabilitation?
Because you...
Plot twist. They didn't find him until Houston police picked him up for aggravated assault with a deadly weapon. Yeah. ... Definitely not just skipping AA meetings at this point.
You were arrested in Houston for aggravated assault with a deadly weapon. And then in May, we get you back here and you were sanctioned to 180 days in jail. So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. I gave you upfront time, continue you on probation. Courtesy supervision was sent to Harris County, and then we have the scram device issues still, alcohol violations, interlock violations, aggressive behavior, ongoing alcohol use. So if you didn't do the relapse safety, it's not anyone's fault other than your own, because if you didn't know about it, it's because you weren't going to probation. Mr. Nichols?
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
Multiple times.
Yeah.
And I don't know what else we can do. So obviously I agree with the probation department's recommendation for revocation. I think he's had more than enough chances. In fact, there's just one thing I don't make the court aware of. I can call Ms. Martinez.
Yeah, sure. Ms. Martinez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead.
Ms. Martinez, you were supervising. Ms. Mendoza was on all years and we were back in October when we started having these violations.
So probation tells him, hey, turn yourself in. And his response? A literal ha in an email. Brew. This man's got the...
Okay, you can't make this up. Probation emails Mendoza, telling him to turn himself in for violations, and his entire response is just one word. Huh. The audacity is off the charts. In legal terms, that single email shows willful defiance. It's not confusion, not a mistake, but blatant disrespect for the court's authority. Judges hate that, and honestly, can you blame them? If you're the court, how do you trust someone who mocks the system with a one-word laugh? Let me know in the comments if you were the judge. Would that HHL alone seal the deal for revocation?
The audacity of a Marvel villain.
What was his response to you?
he had responded with an email that said ha.
That was his only reply to you. Now, did I ask you to put me on a copy of that? Showing you what our mistakes is. Which is hearing this copy of the email is starting the court for purposes of this hearing, I'll offer statements of employment.
It's admitted.
And is that pretty consistent with his level of cooperation and probation officers?
Yes.
No question.
Any questions?
Just a couple. I want to clarify on the relapse program. You said he was in y'all came to court on motion revoke, is that my understanding?
Yes.
And so the safety relapse was ordered by Judge West, and he was here, the defendant was here, Mr. Mendoza was here at the time. Wouldn't he have been taken into custody?
Looks like the hearing was completed over the phone. It was over the phone when the supervisor at that time did residing in Houston, reported to get a lack of transportation to report back to the hearing. At that time, because he had tested positive for alcohol and cocaine, the supervisor had recommended complete relapse therapy and issue a warrant for his arrest. So he was made aware at that time that he was going to have a warrant for requesting relapse therapy.
I have no further questions for the judge.
Right, anything
I have no
else?
other questions.
Thank you, Ms. Martinez.
I think he wanted to address the court, but we never did, because
Sure.
we talked with her.
Go ahead.
Check with the court. Anyone know the court?
I'm saying I went to safety twice. I never went to
Nobody's saying you went to safety twice. We're saying you went to safety. Hold on, don't listen. I'm going to let you talk, but don't talk over me. We're saying that you went to safety and then that you were ordered to go to the safety relapse, but you never came and turned yourself in after that phone call where you were told that there was to be a warrant for your arrest. So no, you never went to safety relapse.
This is where it really breaks down. He admits ignoring court orders but blames the system, the device, the job, everything but himself. Classic "it's not me, it's everything else" defense.
Go ahead.
She said it was supposed to be something that was after it was the 9 months. When I was here, they let me out. And then I was trying to work. They kept saying that I was
Okay.
so I was actually at work. She sent me a message to my phone. I'm trying to pay because since they were violating or operating the truck without permission. So that's when I just did the terms.
Right. So did you respond? Is that email? That's what you thought about all that?
That's what I did actually.
You thought that was funny?
It's, I was taking a check to work. I was trying to, these days, trying to make money to take the classes. Being on standardized.
Well, you had money to buy alcohol. You hadn't, because you kept drinking, because you kept messing. I mean, Mr. Mendoza, you have been given so many opportunities on this probation, and
Here's the part you
This is the heart of the case. The judge spells it out. Mendoza has been spared revocation 3 times already. Instead of prison, he was given treatment, probation, extensions, even upfront jail time, all designed to help him succeed. And yet, he kept testing positive, kept drinking, kept violating. Here's the truth, Bob. The justice system isn't endless with mercy. At some point, accountability outweighs compassion. Viewers, let's get real. How many chances should someone get before the system finally says, enough is enough? 1, 2, 3. Drop your number in the chat, because this judge clearly hit hers.
need to hear. The judge didn't revoke him 3 separate times. And yet here he is, still testing positive and still making excuses. At what point does mercy run out?
understand that those things are expensive. However, if you had at any time stopped testing positive and having blood alcohol readings that were positive on those things, then you could have eventually gotten off of those. I don't keep people on those for very long. But the reason we had to keep doing it for you is because you kept drinking. You kept messing up. And so you don't get to say, I kept messing up. I mean, seriously, you got the initial probation in 2021. you got relapse, you got safe P, you got some upfront time because of the Harris County issue, didn't revoke you, haven't revoked you, 3 times haven't revoked you, and here we are with all of these violations.
Supervising me and made me do these things like I said.
Well, how old are you? How old are you? 43 years old.
And I have no felonies on my record except this.
That doesn't mean anything. You have this felony and you have 6 years hanging over your head. And you've been given all the tools. You went to safety, you got the aftercare. At some point, you have to take those tools and do for yourself and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking. We gave you the tools. We're done. We're done. No, we're done. Mr. Mendoza, turn around. You can say whatever you want, but you're going to face me and you're going to get your sentence. And if at this time I could give you more, I would, I promise you, but I can't. So I'm going to find that you entered your pleas of true to counts 1 through 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you.
And there it is. The judge revokes probation and sentences Mendoza to 6 years in the Texas Department of Corrections. After multiple violations, endless excuses, and outright defiance, the mercy ran out. This case is a textbook example of how probation works. It's a privilege, not a right. Courts will give opportunities for rehabilitation, but when those are ignored, prison is the inevitable outcome. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp, stay informed.
Just 6 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a certification of your right to appeal. This was not an agreement, so you do have some rights to appeal. Y'all need to sign that before you leave right now. You need to sign that you're getting a copy of it, and then we'll give you your copy, and then when you're done with that, you can go back with the bailiff.